cover about 15 minutes. So I'll just run through as fast as I can so that we have prepared for today, and the patent registration process for MSMEs and innovators. We will capture the navigation process, patent registration process, and how you can strategize as as an SME or an innovator to be able to seek for patent protection or registration for invention, and other tools that you can use to utilize for protection of whichever creation you have or in an invention. So we will be looking at the concept of intellectual property, a general what IP is, what IP entails, and then why should you protect your invention. Then we will now narrow down to patents and how you can get value from patents. IP actually refers to the creation of the mind, and it could be invention, could be literary and artistic works, be symbols, names, image, and designs. And I want to emphasize here that IP is not an idea. It has to be an expressed idea or an invention, a creation. So that is what we refer to as an IP. Now, when you seek protection, it now ceases from being IP to be an intellectual property rights. And that right is usually granted by a government agency. So in Kenya, we have two forms of intellectual property rights. One is the industrial property right, and we have the copyright. So industrial property right, we have patents, we have trademarks, we have industrial design, and and utility models, those four. And then we have a copyright where we have the neighboring rights and related rights, which just simply means the same. So those are the two major categories of rights that are given by the government of Kenya. So industrial property right, we seek protection from, or we get those rights from an agency of Kenya called the Kenya Industrial Property Right. Now, for copyright, we seek protection at the Kenya Copyright Board. So we will not dwell into copyright today, but just to say that most of the creations, especially that are in the digital economy, more often than not, we find that they are aligned to copyright because software, for instance, in Kenya is protected under copyright regime. We call it the literary works. If you sing good music, you compose a music, all those are under copyright. If you write a book, a novel, all of them are categorized under copyright. You can seek a right called copyright. Now, for industrial property right, the first one I will talk about is the trademark, which is given to names, symbols, brand names, and logos. So if you are able to come up with a brand name, and I will show you an example as you actually get a trademark for that. Then we have industrial design. Generally, they are referred to as registered designs globally, but in Kenya, we call them industrial design. So that one, we're looking at the shape, the aesthetic value of a shape. If you look at vehicles, we have different forms of vehicles. We have Aston Martin, we have Toyota vehicles, and premium, whichever they are. Their shapes are different from one another. Under what we call trademark. So if you register for it, and then you can renew it indefinitely. And then now that is for trademark. For registered designs, it's 5 years. Then you can renew it 3 times, up to 15 years in Kenya. Then we have, of course, copyright I've already mentioned. So I will move slowly into patents. But just before I get into patents, why should you protect an invention? Number one is that if you want to ensure that the future position of your entity is well established, then you have to protect the invention. Lest you get into the market and then you have no grounds to, oppose anyone who is, utilizing the same invention that you have. So you have. If you miss to seek protection, then it means anybody else can use it, and there's no way you will take them. Remember that Kenya is a common law country. Now, when we speak about common law countries, we have to ensure that our inventions are protected. In civil laws, you can actually argue that you had already documents that are protecting your invention, but being a common law country, then it becomes a little bit difficult to enforce an invention that is not protected. And when I say enforcement, or I'm just simply saying that it is difficult for you to be able to navigate in the market and stop other people from using your invention. It becomes very difficult if it is not protected. So ideally, when you seek a protection for an invention, you are simply ensuring that you have a maximum authority of your invention. So these are well-known trademark called the Apple that has been for laptops, and it's been valued to be very expensive marker inventions, but they are not able to get a registered name. So you can actually use this route and just protect your name and get a lot of reputation, because a trademark actually identifies you. Like if you look at Apple, it is an identity that has won the market in the laptop industry. We have different forms of industrial designs, and this is just some of them. You see how Samsung moves from S22 to S23 to S24. It's just the aesthetic shape they're changing. Of course, there are technical effects which we look at, and but we're just looking now at the shapes that have different forms of shape. Those ones are actually protected under industrial design. So all this, as you can see, that is displayed here, have their own form of shapes, and they are protected in different, are protected as registered designs. Then, as I mentioned about copyright, application softwares, computers, and you have come up with an operating system, which is just a coded form. It's not a technical. Of course, it leads to a technical effect, but the source code itself, we can actually seek for protection under what we call copyright. So generally, I just want to mention here that all these forms of regimes can be sought for an invention or a creation that one has come up with, and you can seek it in different forms. So for instance, I want to use an example of a wheelbarrow, which has been propagated in the political industry, but I want us to look at it as an invention, and I want you to just imagine how a wheelbarrow looks. So that wheelbarrow, the way it is, you can come up with a different shape of the wheelbarrow, assuming it has 4 legs, and then maybe where the bowel is, you change it to be trapezoidal or whichever shape you give it, but it has some different form of shape, but it achieves the same function. Then that one, you have an industrial design that you seek protection for. So if it has you put a computer, you computerize it and write a source code and say that your wheelbarrow will be recording the weight and the load that someone puts on it, then that source code that you have can seek a protection under what we call copyright. And then the technical effects, as far as the connection is concerned, assuming you have added more, maybe it has now 3 wheels, it has a chain that attaches the first wheel to the second wheel, and it's completely different. Then you can seek for either a patent or a utility model. So I normally advise most SMEs, because of the different forms of protection, you can actually leverage on one. And once you seek protection, it means that you have ownership for it. And we'll get into the discuss about ownership and what rights you are conferred as an owner of an invention. So patents are a mechanism for protection in technical inventions. And it means that you have value, and investors can see value in what you have. So if you are an SME running, maybe you having an invention, and you are selling in the market, but you have not sought for protection, you can actually take this point and have a protection through patents if it has a technical effect. So in Kenya, I will get into filing, but just to preempt that there are different forms of or subject matter that Kenya Industrial Property Institute will look into for you to be given a right called a patent. And one of the key things is that it must have a technical effect. And a number of people have argued that when you seek for patent, it means it has a negative right, and it cannot be done by others. But on the other hand, the negative right is a short term, it's only 20 years. After that, it means you will lose the invention now it will get to what we call the public domain. So anyone else can use it, can sell, can, manufacture whichever way they want. But before 20 years lapses from the date of filing, if you file today, it will run for 20 years. And at that particular point, nobody else will use it. So it simply means that you as an inventor or an SME, you will have monopoly rights and nobody else will be using the same invention in the market. So, of course, I've already mentioned on monopoly lasting for 20 years from the date of filing. But before you do the filing, and now this is an area where we really have a lot of challenges, especially for SME. How are you able to do the patent document? Of course, there's the description, which you have to describe, and it is aligned and arranged in a legal format. And there is where now we come in as patent agents to support and assist so that you can be able to, have a well-crafted document that runs from the abstract all the way to what we call claims. Today, we will not talk about patent drafting, but just the description of how ABCD is connected to XYZ. For wheelbarrow, you say the wheel, probably how it is attached to the third wheel, how the chain are connected, and all that you put it together to be able to have a well-crafted. Someone is talking? Well, so there is the social bargain where we are saying the state gains a monopoly right. Of course, now that 20 years from the date of filing, but you have to disclose your invention. And the disclosure is basically on the description of the document that we support and help in, drafting. So in other words, as a social bargain, there's just exclusivity. You have to define the technical area, and then there is a chance to recoup your investment. Once you file, and it's known that you are the owner of that invention, it means that if an investor is interested in your invention, then they will only bargain with you. And there are different forms of commercialization. Of course, those are not what you're going to look at today, but you can now choose which route to, work with an investor. And if you want to do what we call self-exploitation, then that will be up to you as an inventor, but you will be having a monopoly of 20 years and nobody will leverage on your product. A number of instances we see, especially in Nairobi industrial area, if you go to Gikomba, once you start a venture today, the next day someone opens up a shop with the same venture that you are doing. And it goes on and forth until at a point where you are not, so they become competitors of your own invention, and that becomes very, very difficult for you to recoup the investment or the money that you have put in your invention. So it becomes, you begin competing with your own invention, and that becomes very, very difficult. So otherwise, we say that patent system generally stimulates innovation. Once you get reward for your invention, it simply means other people would not, would also feel they want to innovate. And as they look at how you are making money, it will spur invention, and all through we'll see people now growing. And people will buy from you, and they would want to learn. As you describe, there will be disclosure, the document that you have disclosed, someone else can read, and they can improve on that and come up with other invention, and in general will be stimulating innovation in the country. So what can be patented? So we say nearly everything that is technical can be patented. You look at a computer, it has a technical effect. You look at all those things that have technical effect can be patented. But to narrow down, you have products, either molecule, materials, new composition, all those can be protected. Then we have apparatus, maybe for making soap, apparatus for making flour, all those purifying, maybe sunflower, extracting, whatever that would qualify for a patent. And then method, also that will be protected, and the process, the steps that we'll be using, those can be protected under patent. Uses, of course, in Kenya we have a problem, but in other countries you will protect the uses of a drug and all that. Like in US, you can seek protection. So I want to state that a patent is territorial in nature, that once you seek protection for a patent in Kenya, it doesn't mean that you have sought a patent protection in another country. or for instance, in US, in whichever country you're speaking about. And then there is the independence of patent, which is also a principle that is tied down under the treaties that were signed by governments. That once a patent is granted in Kenya, you cannot go and oppose it in another country. It means there is that independence in patent protection. But just note that once you seek a protection for a patent in Kenya, it doesn't mean you have sought for a patent protection in South Africa, for instance. And different countries have different aspects they look at. We call it the subject matter that they look at. For Kenya, key things that they look at is novelty. How new is that invention? But when they're looking at novelty, it's absolute novelty. They will search all documents in the world. Then they will be looking at inventive step, simply meaning that what you have come up is not obvious to someone else in the same field of that patent. And then they will be looking at how can it be applied in the industry? Is it applicable in the industry? Or have you come up with a suicidal bomb that when you, the moment you just launch it, every other person around you will die? So in other words, it simply means it cannot be granted. So all those will be looked at, and those are the key things. Of course, the disclosure bit is essential because you have to disclose, and in the process of disclosure is the description that I've just mentioned. And of course, novelty is we say absolute novelty. And anything made available. If someone has written a publication, has published a document elsewhere in the world, then you will not be given a patent for that because it means it is not new. It's already been mentioned somewhere, either in the newspaper, in the journal articles, wherever it is. Or there could be a patent document that has expired, but you want to come up with it as new. You will generally not, Kenya Industrial Property Institute will not grant you that right. And of course, the other things that I looked at is the disclosure, and that is very essential, that you have to describe your invention. Yes. Now, inventive step I've already mentioned, and there is something called a person skilled in art. So if I'm a computer engineer and I've come up with a system that is purely computerized, and I'm saying this is new, if someone in the same field is a computer engineer, if he looks at it, he should be able to say that indeed there's efforts that have been put into coming up with this invention. So we say that an invention will be or may be inventive. It has an expected or surprising result. And, if that feels say, wow, this guy has come up with something that is really, really new. And I think this needs to be protected. And of course, it's not obvious. In as much as something is not written, there is a possibility that is just obvious. For example, if you are making tea, you have come up with a process of making tea. Then you say that when you add in lemongrass, for instance, it will make that tea, taste better. That is just an obvious kind of a thing, and will not actually be protected as a process of making tea, for instance. So there are general exclusion from patentability. One of them is a method of medical treatment. And this is basically in Kenya. In US, a method of medical treatment will generally be protected. But in Kenya, there is no protection for method of medical treatment. Then we have computer programs. So in Kenya, the Kenya Industrial Property Institute does not protect computer programs. If you have a good computer program, you could go to Kenya Copyright Board. Then mathematical models, formulas, and all that are also not protected under patents. Of course, presentation of information like what we are doing today, these cannot be protected as a patent. Good method of doing business, you will go and seek for copyright. A number of these exclusions or all of these exclusions can actually be protected under copyright regime. So if you have this, it does not mean that you cannot get a right for it. You can go for and seek a right in a Kenya Industrial Property Institute, and they will generally, in Kenya Copyright Board, and they will generally grant you those rights. If they are actually new, they also look at some of the other things that they look at, and then they protect that. But for today, we'll not get into that. So generally, there are not many restrictions in the United States, and the US has been trying to improve their laws to be able to ensure that every inventor has their rights protected. We are hoping that as a country are going to get a national IP policy, which will be looking at some of these things. How can we improve our laws so that it takes care of so many other inventors and creators and all that? So an inventor and ownership, a number of issues arise here, especially if there's a policy-related matter. So if you're working for an SME, assuming an SME has 5 employees and you are one of them and you come up with an invention, does it become, does the inventor becomes the owner of that invention, or it becomes now the SME owns that invention? So you have to look at some of this, and I would advise SMEs to be having such policies that stipulate who owns the who owns the invention, and what are some of the if my employer in my SME comes up with an invention, does he get a right for it, and what are the terms? So you should be having a simple policy that can stipulate some of these things, and it is very critical because in this digital age, I have had instances where someone comes and says, we have come up with an invention in the firm I'm working for. And when I wanted to protect, I was told no. When I signed the contract and terms of employment, is stipulated that anything that I come up with, it becomes complete ownership of that company. So those are some of the things that have to be looked at. I will try to rush through because I think I spent more than 15 minutes. So I will dwell a lot of time, around 3 minutes here, to just give a proper description on what process or the process of filing. So while you are filing, when you begin the process of filing an application, first of all, you have to get a patent agent who drafts a patent for you. And after they have drafted that patent, then that patent should have pure specification on what a patent is. So as we navigate through the process, the first stage of either a failure for you to get a patent is either having a bad attorney or a good attorney. If you get a good attorney, you're good to go because you will save a lot of money. Remember, when we are doing the filing, you have to pay 3,000 filing fee, Kenya shillings. You'll pay to Kenya Industrial Property Institute for you to seek protection. There are generally 2 forms that are filled, the IP3 form and IP4 forms. One stipulates on who are the owners and who are the inventors. And then the IP3 is now you are seeking specification. Now you are saying you are filing for this. It's generally like a letter, like you are trying to say that I'm now filing for a patent. Then you have to identify who is the applicant. And that's why I was saying you have to be very clear on ownership, because if I'm an inventor in an SME and the policy of that SME says that an inventor cannot own it, simply means it's the SME who owns, then that means they become the applicant and they only become an inventor within that SME. And then you have to purely describe the invention and have properly drafted claims. Remember, claims are the subject matter of protection. So those are some of the things that you have to really draft well. Just to mention that when a patent document is described, it has to capture each and every detail, so that in the process, and we look in this filing procedure, that if it is knocked down by an examiner in Kenya Industrial Property Institute, you can simply go back and edit your claims, but it has to be supported by the description. Now, the problem comes when you describe less and you want to claim more. If you describe less and want to claim more than what is in the description, you will not be given a patent for that. So you have to clearly and completely describe your invention. So you have to have a good patent attorney for that. And then, of course, the other thing is that payment of fees is compulsory. And the important thing of paying that 3,000 for application fee, one is that it gives you a priority date. If someone else the next day goes and file an invention similar to yours, they will not be given a patent. They'll say that someone else who filed. Or an hour later, they will not be given because you have already filed earlier than them. Now, of course, those are the key things that are looked at. And we normally refer to this as minimum requirement. So from this, if you have met all the application fee and you have paid all that and you have done proper description, they will give you a filing date and they will notify you. Keep will write a letter showing, indicating that you have been given a filing date, and that filing date will act as a priority date. Priority date simply means that you are the first to file. And in other words, if anyone else files the same invention, will not be granted rights because you already came earlier. This filing date is very important, especially if you want now to go to, there are other routes you would want to file. Maybe you want to do an international filing. Your filing date will mean that you have up to 12 months to file to other countries. So if someone else files within that date, before after the date that you filed in your country of origin, or where you're having a real or effective industry, it simply means they will not be given the right, because your date was the first one to be recorded in a national IP office. So after this, there's a formality. Generally, they're looking at the margins of that patent document, whether the application is incomplete, it has an abstract, it has claims, it has, brief description of the diagram, it has the summary of the invention. There are a number of things they look at, but today we'll not look at the patent drafting, for instance, but that is what they look at, and how your document has been properly drafted. If you meet that, then you will still be notified, and they will say that now you pay and for examination, so that they can do now what we call the substantive examination. If it doesn't mean, they will tell you go and correct ABCD, then you can still proceed and correct where there are errors. Then now do a proper filing, which will now again go through a formality examination, but you will still have your filing date recorded. So it will go for formality examination. And after that, then of course, you will be notified, and you will be notified to pay for substantive examination fee. Normally, it's about 5,000 for a patent for substantive examination. Then from there, you will be requested to, of course, you have been requested to pay the examination fee, and substantive examination will be carried out. They'll be looking at unity of invention, that whatever you are describing is on a particular invention. You're not describing two inventions in one. So they'll be looking at that. And of course, full disclosure. And then the non-excluded subject matter, which you have said, like methods of doing business, mathematical formulas, and all that. So they will be looking at that. So you have to be very careful at the point of filing, because you will be spending this money. This is 3,000. You have already paid 5,000. And again, there are annuity fees, which I will show you in the subsequent slides. And that money you wouldn't want to waste. And of course, there is a patent agent who you are paying to assist in the process of filing. So all those will be checked, and you have to be very careful, don't to lose money. And you know, right now as a country, we are struggling with the taxes, the NHDF, and all that. Those things are coming up. So if you are missing out on wasting money on areas which could be actually saved, then you will have a lot of problems. And of course, after substantive examination has been done, you will be notified. One, you'll be notified either to amend the claims, and if the claims are it cannot be amended, and you're feeling maybe your discussion is good, you can convert it to a utility model. If maybe they said it has novelty and it is industrially applicable, but it doesn't have inventive step, you can convert it to a utility model. Then after this, maybe you have done this correction, and your patent agent will support you in that. You can now again file. They will do the substantive examination again, and if it merits, or if you have changed the claims and they are okay, then you can be granted a patent, and or it can be registered for that matter. So just to run you through, once you have filed, we normally have a maintenance fee. This is not the real amount, but just to note that at the 20th year, you will be paying 20,000 Kenya shillings, and at the first year, you'll be paying 2,000. So it is usually 2,000 up to 6K in the 6th year. Then it goes to the 7th year, it's still 2K, 8th year is 8,000, and then 9th year, 10,000 as it continues growing. So it's generally assumed that after you have patented, the most important thing is that you must commercialize. So by the 3rd year, in Europe, most investors or business people, or I would say those who have patents, after the 3rd year, if it is not making money for them, they normally abandon. So it is important that when you are filing, you should have the end in mind and look at that patent as a commercial viable patent. Don't just patent for the sake of having a profile. We encourage that you patent so that you may commercialize and make money from your patent or invention that you have. So I will stop at that. I think my time is formation. Or if I have more time, I think we can continue, Clarisse.
We still have around 21 minutes left. So in case you can finish your slides, then we'll do Q&A for about 15 minutes.
Okay. So we have anatomy of a patent. What generally a patent document will look like? Number one, it must have a title, and we have a format of doing the titles. So again, I would still say that you have to be guided by a patent attorney to have a proper title for your invention. And you know, a number of inventors, they come up with invention, and looking at it, generally it is just a description, like if it is an application system, or let's say a process for making flour. One will just say, will come up with a title that does not merit for protection. So generally, you have to be guided, and it has to be uniformative, and it has to be very clear. If it is a product, you say a product, and if it is a process, you say it's a process. If it is a product and process, probably use a system for that matter. And then an abstract, which is usually about 150 words. So it is very critical, and a patent document must have an abstract. And then generally, the abstract just informs any reader that what your invention entails, and it gives an overview for any reader to know what that invention is. So if I'm doing a patent search, for instance, when I read an abstract, I will know that this patent relates to this field, or it doesn't relate to this field. And then the description, which will be having a background and a background art. The background art, you are simply saying that other people have done several things related to this invention, but my invention is different from this. So the difference of that invention, you will do it in the detailed description. You are now referencing it with the diagrams, and the diagrams you have to label, have numbers and all that. And then, of course, from that diagram, you do proper relation with the description, and you also have to do brief description of those drawings or figures that you have put in the document. And then now the claims, and the claims are actually the legal matter, or where the scope of protection is. So you have to really say that I am connecting X and Y to achieve a certain particular function. So that connection, if that is the new thing, you have to claim it and properly write that claim. So, and there are different formats of claims and different ways claims are written. I think for today, we'll not get into that. But that is the most essential bit of it. And claims are supported by the detailed description. If your detailed description is limited, it means your claims will also be limited. You cannot claim what is not described in the document. A number of creators come up with invention, and they don't want to, expound clearly and elaborate on what they have come up with. So because they feel like when they describe, someone will steal it. But the essence of you seeking protection is to ensure that whatever you have is well tied in that document. And if anyone will come up with something similar to what you have done, then they will not be have a protection for that. So generally, this is the anatomy, or what a patent is, or a patent document. Generally, this is a must for a patent document to have. And in most jurisdiction, you will have this as essential part of that patent document. And now I was saying that a very critical essence is that you must get value from your patent. Remember, patent is just like is a property right, and it's just like the way you will buy land and then look for a title deed, go to the lands registry, and you are given a title deed for the same. A patent is the same way, but now this one is now an intellectual property, your creation, your invention you have come up with. So you are going to seek for a protection. And the most important thing is that in the process, as you navigate through the process of acquiring a patent, at the end of it, you must be having a target, and that target should be value for money, and or rather value for your patent. So you have a patent that must have a value. Of course, there are various ways and other methods that people do, and of course, experts would assist you to value it. But the most important thing is that once you have a patent, try to see how you can commercialize it to make money from it. And then there are different forms of commercialization. One is you can license your patent so that you get value for it. And there are various forms of licensing. It could be exclusive, it could be non-exclusive. And then there is also the assignment, which you can actually decide to just sell out for it to a third party and let that third party make money or, be giving you royalties, no, give you a one-time money for it. Once you do an royalties, or rather you get value for your patent and you forget about it. So it's upon the third party to decide what you will do with it. But when you're doing an exclusive license, it means you still have, you retain some rights, and depending with the agreement you have with the third party that you have first given the license, you can still proceed and, other parties and so on and so forth. So remember that investors will look for an effective patent protection. If I am an investor and I want to invest in your SME, for instance, I will not just come and look at what you have. I will want to know whether you have protected and you have a patent for it, and you have done proper documentation. All those other documentation they will be looking at. But critical to it is that you must have an effective patent protection strategy as an SME. That when an invention arises, what are the steps you will take to ensure that it is first of all protected, so that when an investor comes, they are aware that they are coming to someone who has already sort of patent protection, or an SME that is well established and they have done a proper documentation of their invention. There's this freedom to operate that you give assurance that third parties will not be able, to stop you entering your marketplace. In other words, once you have a patent protection, it simply means that in the particular country that you have sought protection, it is giving you a right. And so if I'm giving a license to an investor, he is sure that he will not get other competitors in the market who will be, pulling same strings as other people, because already there is that monopoly rights, and you are simply transferring that rights to that investor. Then there is the entitlement of inventorship, which gives assurance that no one claims or can claim the IP or otherwise invalidate that patent. So these are some of the things that inventors will be looking at. And of course, the other critical element, maintenance, that your invention is properly maintained to ensure that nobody else, just a minute, just sort out something shortly. Moment, I'm in a meeting. Okay, I'm coming. Okay, I'm coming. Yes, sorry for that. I happen to be at home and I'm getting some little bit disturbance, and sorry for that. So I was saying that you have to ensure that your invention is properly maintained. And once you maintain your invention for 20 years or whichever time you have maintained it, when an investor comes, they look at, have you maintained it? Because if you have not maintained it, it means you have abandoned your invention and someone else can, pick it up and utilize it in the market. So those are some of the key things that have to be looked at, and is very, very critical. So I will summarize that we have different forms of IP. Right, the industrial property right, and we have the copyright. So it's if you have an invention or creation and you would want to have it looked at, so that you know which forms of right you can seek for, then it is very critical that you can always reach out, and we can always guide you. And then the other thing is that protect your invention. Do not wait until once your invention has been stolen, then that is when you want now to seek protection. The moment it's stolen, it's very difficult to regain it. Remember, these are common law country. I have had an instance where an inventor, especially the young innovators who have come up with invention, they go for this, booth, and they are, they want to, seek support and all that. So the moment they share it out, someone else who sees it as a very valuable invention, they will not come to you. They will not give you an award. What they will do is that they will take that invention and they will quickly scale up. And we are not equal in as far as pocket is concerned. So if you have more money, it simply means you can easily take someone else's idea and move on with it. So you have to seek protection at the very, very early stages. As long as you see this, there is something that has come out of what you have done or from the experiments you have done, then seek for protection. And of course, you have talked more about patents. I just want to mention that if your invention is a minor invention and you're looking at it as a mere improvement of what exists, you can still seek for what we call utility model, which is 10 years from the date of filing. And the same scope of, description and all that, the same way the patent document is drafted is the same way a utility model is protected. So those are some of the things that you can actually, one of the form of rights that you can actually look for and you'll get protection. Then you can actually get value from your patent or utility model or whatever right that you have sought for. And it is very critical for you as an SME, for you as an innovator, to actually seek for protection for any creation or invention that you come up with. I want to stop there, and I will be taking questions.
Thank you so much, Jenna, for that excellent presentation. We'll move on to the Q&A, and I can see we've already received some great questions in the chat. I encourage you to also just raise your hand so that you can unmute and voice your question as well if you're not in a noisy background. So I can see Patrick Murimi is asking, what are some common, or Jenna, how do you want us to approach this? Should I read out the questions and then you'll answer one by one, or I read out one and you answer? I read and you answer, I read and you answer. Or I just read out all the questions, then you answer you tackle all of them at once.
I think I can handle question by question.
Okay. So Patrick Murimi is asking, what are some common mistakes innovators make during the patenting process and how can they be avoided?
One of the major common mistakes that innovators make is that they get excited when they have an invention, and at that particular point, they want to share it with every other person. That is with share the invention. And then they forget that needs to be protected. That is one major mistake that I have noted around. The other biggest mistake that people do is that they don't do proper, patent agents, seeking proper or utilizing proper patent agents who can support them in the process of seeking for protection. And we have the Inventors Assistance Program, which I am in, which you don't really necessarily have to pay. You simply go to Kenya Industrial Property Institute and say you have an invention, but you don't know how to, file for it. So what Kenya Industrial Property Institute will say, they will look for one of the agents who has been enrolled in the Inventor Assistance Program, and they will support you in the process. And I want to state this, that always have agreements. Write down, whenever you meet someone, let them sign that they will not disclose. This is what we call the non-disclosure agreement. You can just simply craft it and have that, walk around with it, so that when you're meeting an investor or you're meeting someone else, if you have not protected, let them sign that they have had, so that in future, if you hear them talk about it elsewhere, you can say that there's an agreement we signed that you should not disclose, and you can use that within the legal frameworks to seek compensation if they have already commercialized. So that is very critical, and I think those two mistakes have been evident in a number of ways. And once you lose your invention, that is it. You cannot regain it. Yes. I hope I've answered your question, Patrick.
We have another one. Which organization is better when filing a patent, ARIPO or KIPI? And does ARIPO cover several countries as compared to KIPI, which only covers Kenya?
Yeah, I think I missed on mentioning on the filing routes. We have 4 types of filing routes. The first route is the national route, where you file to Kenya Industrial Property Institute of Kenya. And then there is the Paris route, where you move around to other countries looking for patent agents in those countries or patent attorneys in those countries to file for you. Then there is the International Patent Cooperation Treaty, which you file to International Bureau, the IB of WIPO. Then they will ensure that your patent is protected. But you have to designate in those states. So, and then there is now this regional route, which now you file to a region that you belong to. We have a number of regions. We have OAPI, we have African Regional Intellectual Property Organization, which is in Harare. We have the EU IPO, which is in the European Union, as well among the regions that we have. So what normally happens is this is more of relations that countries sit together. They have come up, like now ARIPO has 18 member states, and they have agreed on a protocol that they will use in filing. So there is no better office, so to say, because they are differently mandated and they seek protection differently. So, but for you to seek protection in ARIPO, you must first file in Kenya. That's out the Harare protocol, or the protocol that has been put stipulates. Then after you have filed in Kenya, you can now proceed and file to ARIPO. Then within ARIPO, you have to also designate the number of countries that you can seek protection in. It depends with your business approach. Where do you want to do business? Remember that filing there's also maintenance fees in a number of countries if you are going to file a number of countries. So what I normally advise innovators is that seek protection where you want to do business. And that is very critical. Of course, there are other things that come about, like parallel importation and when does exhaustion rights, and when, at what point do you exhaust your rights? And it is possible that you can seek protection in, for instance, Tanzania and Kenya, and someone sees what you're doing, then goes to Uganda, uses very little cost in Uganda, and still come and sail back to the country that you have. So it will depend with the competition laws of the country and what it stipulates. Yes, thank you.
Another one is that, is there a way to register remotely, or a potential patent owner has to physically visit the KIPI offices?
Yeah, you can do poster to KIPI. You can visit physical KIPI and file, but there is no remote. But what I know is that KIPI is now moving to eCitizen. Right now, we do payment through the eCitizen portal, but you still have to submit the documents to KIPI. So that is an area of improvement. I am not an advocate for Kenya Industrial Property Institute, but I can just say that from general practice is that we have been going there physically, and you can do post. Maybe you can post, then it's delivered physically to Kenya Industrial Property Institute. Remember, these are legal documents, and legal document, it's always important that when you deliver, there is a countersign that they have received that document. So that if at one point you have lost a filing date, you can say, I filed earlier than this one, and here is a document, a stamp from Kenya Industrial Property Institute, indicating that I filed. So why is it that someone else is propagating the same invention? So you can have a legal basis to pursue such a process. So just to say that we still don't have online filing as far as Kenya Industrial Property Institute is concerned. But for copyright, we do online. Registration is online. There is what we call the National Registry System, the NRR, where you just file, and you can open an account wherever you are and file, and you will be given your right if it merits the examination at Kenya Copyright Board. Yes.
I can see Jerry has his hand up. Jerry, you can go ahead, and then we'll continue with the questions in the chat because there are more.
Wonderful, Clarisse and Jenna, for hosting this wonderful webinar on intellectual property. I hope you can hear me.
Yes.
Yes.
That is indeed really good insight from an expert, and I'm really happy that I've learned a lot. But there are some 3 quick questions just for clarification. The fee is always very high. Lawyers like Clarisse would sometimes charge up to 300,000. That is a whole university fee. If you just add only maybe 100,000 and you graduate. So why would a patent cost that much? And even if it comes to patent agent, it's still very high. That discourage even young innovators from patenting their products. Number 2, non-obvious. If what is obvious to a certificate expert is different from what is obvious to a degree expert and a PhD expert, and also traveling and exposure. You may be saying that something is obvious to you, is non-obvious here in Kenya, but somebody who traveled to Italy last month found that thing already being implemented there. So what is the boundary of this non-obvious? Finally, when you are patented, is it some product you can now walk to an industry and say, this is my patent, can you purchase it? Or how will you commercialize this patent? Because I think you cannot auction it like any other product. Thank you.
Thank you, Jerry, for those interesting questions. When you say the first question of the fee is high, I would say fee in KIPI is relatively, okay, is arguably not high. What is high is the fees for lawyers or patent agents. But as I mentioned, there's the Inventor Assistance Program that innovators can utilize. You just go to Kenya Industrial Property Institute, then they will get someone who will support you and assist you in drafting the document. It is called Inventor Assistance Program, and it's a voluntary program that Kenya Industrial Property Institute collaborates with World Intellectual Property Organization to support innovators, and they will give you someone who will assist you. I have supported a few who were directed to me by Kenya Industrial Property. So you should not be worried about the agency fee. What would be a concern to you will be the fee that you pay at KIPI. But remember, the fee you pay at KIPI is not a one-time fee. Application fee is 3,000. Then there is the examination fee, which is 5,000. And maintenance fee for the first year is usually 2,000. So by the time you are getting your patent, you would maybe have spent about 16 to 18,000, and which is not paid a one-time, is not a one-time fee. So you can have strategies where you are able to, and then note that, and this is very critical. A number of people wait until they get a patent certificate for them to start commercialization. You can start the process of commercialization the moment you have filed for your patent. So as you file, you start looking for investors, and those investors will bring in money. And when they bring in money, especially if your patent is a high value patent, you will get an investor very fast. And if it's actually solving a really problem in the country or whichever area you are into, maybe say in agriculture, maybe a post-harvest issue that is affecting so many people, you will get money for that. And it will help you to, do the maintenance, pay for the other fee. By the time you're getting your patent certificate, you are already in the market and you are rolling. Now, the issue of commercialization, which is an entire subject that I didn't want to get into, I can say it will all depend with your strategy. But one of the most important things that I normally train is on the business plan, and in a way that your unique value proposition is targeting the people or the market that you are looking at into. And the way you link that value proposition would really determine how you get your money. So you have to look at that, and it's a big area, but there are various routes. I have already mentioned on the licensing route. I've already mentioned on the self-exploitation, and also there's the other bit where you can now do either exclusive license, non-exclusive license, or you do assignment. I give out it all and let the investor deal with it. So it all depends with how you are looking at and also the strategy and where you want to get as an innovator. A number of issues that in the general practice which we have been seeing around. As an innovator, it becomes very difficult for you to commercialize because you want to continue doing more research and improve on that technology. So you can actually look for a partner or a license that product and given an exclusive license and continue doing more research so that you invest more in your research, do more research, then don't you as an individual do commercialization. Go ahead and do what you call licensing. But it depends with the invention that you have. You don't go to industry area and say I have a patent maybe for processing biscuit, and you have gone to industry area and you say you want to process biscuit. You have and you're feeling, even in the business, there are so many different dynamics in the market. So there's a lot when it comes to commercialization. But I can say that you can still get value for your patent if you have a proper strategy of getting into the market. And we can always see how we support and guide you through the process. Yes. I hope, Jerry, I've answered your question.
Yeah, you have answered my question. Only the last one that none of us. To me, I still feel that somebody who is versed in traveling would say that this thing is not obvious. Is obvious because I've seen it just in Italy, or somebody who has just done certificate in chemistry, something would not know about nanotechnology. So me who has gone to South Africa will say that nanotechnology has been there for a long time, but somebody may say not obvious. So how do you gauge it?
Yes, these are treaties that are signed, and one of the treaties or the key treaty that was signed is the Paris Convention, and that treaty directs all member states that they have to look into that. So when they're looking at novelty, they look at absolute novelty. They will search documents across the world. So it doesn't mean that when you know it today, someone else did not know about it. Or if your academic levels are lower than someone else, that means that now when you do something, that means that you have now become very inventive. No, it simply means that it is something that was already known and the people already know. So we don't protect something that is already known. Legally, you cannot. It's just like land. You cannot go and say that because I've gone to Masai Mara and I've seen land is idle, I can now go and get a title for that land. It doesn't work that way. It's the same. These are property rights, and it is governed by conventions that have been signed. So inventive step is very critical. It has to be inventive. But what we normally encourage inventors is that all is not lost. We have utility model. And utility model protection, when they are doing examination, they rarely not look at the inventive step. What they look at is novelty, and they look at whether it is applicable in the industry, and you have done your disclosure properly. So looking into that, then you can actually get a utility model protection, and you can practice it in Kenya and sell in Kenya, and you'll say you have a property right. It's usually referred to as a petty patent. And that's what they look. They look at local novelty for utility model. They don't go for absolute novelty. So if you went to Italy and you saw an invention that is super okay, you can come and improve it, modify it, and you can still seek for a utility model protection, but not a patent, because a patent, they will be looking at the novelty across the world. They will be looking at inventive step, absolute. It must be very inventive. So whether there is someone who did it at a certificate level and there's a PhD holder who already knows about that, then it simply means it will knock you out from getting a right. So you'll get a utility model, but you'll practice it in this country, and you will be making money for it. Okay, thank you so much.
Thanks so much. Yeah.
Thank you so much, Jenna. I can see that it's 3 p.m. already, but we also have more questions on the chat. So we'll deal with these questions, and then for those who will have more questions for us, you can feel free to reach out to us after the webinar. Edwin is asking, when one has filed with KIPI, can they also make an application at ARIPO? And can they also file that application at WIPO? And for utility models and patents, are the costs associated with filing the same?
I'll begin with the cost. Utility models are generally cheaper. You don't spend a lot of money. Actually, a good example is the application fee for patent is 3,000. For utility model is 1,000. The question was on filing. Yes, it depends with your strategy. You can, for you to file for international patent application, you have to actually go to, you have to file to Kenya before you file to international bureau. Those are the laws and statutes that govern that process or that route. And equally for a repo, you file to Kenya, then file to a repo.
Patrick Murimi is also asking what best practices exist for protecting software-based innovations or AI-driven products in emerging markets.
Yeah, that's a good question. We have still, and I want to thank God because we are working on the national intellectual property policy for Kenya. One of the things that is coming out is on how AI can be protected. And I think those are some of the things the policy will address. And we need to amend our laws to look into that. But generally, programs, software related are protected under copyright regime in Kenya. Unless you're going to US where they have improved their laws and software can actually be protected under patent. Like the M-Pesa application is protected under patent, but it was filed in US as a mobile money transfer system.
Godfrey Mwangi is asking what's the procedure for allowing someone to commercialize your innovation, which you've already patented, and offer compensation to you. And then Abishai is asking, how do I check if my product has already been patented?
Yes, Kipi, once I will begin with the last question that Kipi, once they will notify you, you look at the route that I had already mentioned, that Kipi does publication and it will be notified. It will be in their journals that it has been protected. Now, the other thing is which about commercialization, and I think Clarisse, we may want to have an webinar on just commercialization of invention because a number of concerns have been raised. And I would still say it's the strategy that you have as an inventor that will make you get either revenue for your patent or lose it in entirety. So it depends with the strategy that you're getting into the market. So it doesn't mean that you have a patent, it means it's protected. If it doesn't mean that it's commercialable. Like you can actually have a patent, but it's actually not commercialable. Like there's nobody who is interested, or generally the market is not ready for it. And like right now, 5G network, arguably you can say the market is not ready for 5G. So if you come up with inventions that are running on 5G network, it simply means you will have a lot of challenges. And actually the structures that are existing are not supportive enough. So those are some of the things that you would want to look at as you seek for protection or seek for market and investors into invention. Yes, thank you.
In case there is no further question, I have one question myself. There's a question I've been asked before this webinar, and I thought it would be beneficial for the attendees as well. So for example, I have an innovation and I exhibit it or I share it, I publish it. Does that defeat novelty?
Yes, once you disclose, the laws are very clear. 6 months after disclosure or whichever, it will lose. But if it's within 6 months, you can still seek for protection if someone else has not filed for it. Yes. So you can actually go for an expo, but it should be within 6 months and be very sure that nobody else has filed for it. Which again, if someone goes and documents it in the national TV or national newspaper, it means you are losing the novelty for that matter.
Thank you. Thank you so much, Jenna, for this incredible presentation on patent registration process. I can see it has been very engaging because people still have more questions, I'm sure. But feel free to reach out to us. If you have any burning questions, we will be able to respond to you. And wait, I've seen some of you are saying that we should have another session for copyright registration process. Yes, we'll take that into consideration. Jenna has also said that we'll do a webinar on commercialization. We'll also take that into consideration. And please look out for more webinars in future. And we also have a training in IP that is coming up. When you see the poster, please apply, because you'll be able to learn all about these things that you're asking. The poster will be posted on our social media, so just visit the Green and Digital Innovation Hub social media pages and you'll be able to be trained on these issues. And we'll also be giving 5 innovators a chance to get a free intellectual property registration. So please be on the lookout. And I would just like to say thank you so much, Jenna. This has been very insightful and I can't wait to host you again soon. I think Jenna fell off. Yeah, Jenna, I think he fell off. But thank you everyone for joining us. This has been a wonderful session. Thank you. And enjoy your afternoon.
Thank you too.